So Greg and John, you've just joined us. I'm going to share my screen here. Okay, Sandy will let me share my screen in a minute. But we're working off of the email document from Jim Nass about the policy issues. And the first one we're going to talk about, we're not resolving any of these issues, but the group discussion here will give us some information about what direction or what options we want to propose to our large group. And so the first issue concerns courts of record.
Justice Duncan, you have co-host capacity now.
Okay, thank you. So I'm just going to go here. So I've just stacked up our kind of checklist of questions that we want to answer today, or at least identify the issues. So the first one is courts of records. And as this group has talked about, and as all of you know, we've got kind of these, I don't want to call them tiers, but two groups of justice and municipal courts of record and not of record. And it matters because if you're a court of record, appeals from your court go from your court straight to the Court of Appeals, just like they were coming out of circuit court, right? And so there's that kind of faster track for appeals, but we only have a small number of courts of record in the state. So the legislature created the option of becoming a court of record that's supposed to expedite appeals, make things simpler, but very few justice or municipal courts have taken advantage of that. And so that has put us in the position of having two tracks. We have the of record track to appeal, and then we have the not of record track to appeal, which means you go from your justice or municipal court, then you go to your circuit court of record, and then you go to the Court of Appeals. So there's multiple layers there. And at least it seems to me that the reason that it works that way is that if you're coming from a court of record, you just don't have the record from which that the Court of Appeals is going to need to be able to review your case. And the idea is the courts of record, they can just move quickly. They don't have to have everything recorded. There's less procedure there, and things may be more efficient. So one of the questions that our group will need to think about, now we don't have to weigh in on whether or not there should be courts of record or not courts of record. Jim has in his document identified that as a question, but the difference between these two courts really affects what kind of appeal process there's going to be. So there may be a role for our group to play, and I think we should talk about what our thoughts are on these courts of record, because I'm going to pull up a different document here. Because right now we have this two system, and so we're going to have to design, we are in the process of designing the appellate process statutes for courts that aren't of record. And if we think that it's better for there to be more courts of record, maybe the work group just will play some role in educating courts, justice and municipal courts throughout the state about that option, and that might make appeals easier for folks coming out of those. But if we think that there should be more courts of record, one of the legislative proposals that we could make, and Jim has identified this, is that right now there's a restriction on justice courts that are within 50 miles of their county seat from becoming courts of record. And so we might want to explore whether that limitation should exist, because if it is eliminated, then you could have more courts of record and more direct appeals from your local court to your Court of Appeals. So Jim, you've identified both, we could encourage more courts of record, or your document also suggested the possibility of eliminating courts of record, but grandfathering in the 6 or so that we currently have. So I'm interested right now, that's our first issue, and I'm interested in hearing people's thoughts about courts of record and whether our group would want to lean towards saying these are good, and maybe you should eliminate the 50-mile limitation for justice courts, or whether we would be leaning towards saying we've got this awkward two category system and it creates confusion. So I'm going to ask Jim to kind of add anything that you want to add about that policy question. And I'd also really love to hear from Judge Gill about how, if you're a court of record, and what advantages or disadvantages you see to having the process we have now. So Jim, do you want to go first? I think you're muted.
You are muted.
I think still muted on my screen.
Yeah, I'm seeing the same thing. Jim, I don't know if you can hear us.
Oh, we just lost Jim, but we got John.
That's true.
Hi, John.
John. Hopefully Jim comes back. I'll let him in immediately if he does.
All right. Judge Gill, is it okay if we pop over to you and get your thoughts? Are you a court of record? Is your court a court of record?
Hey, thank you. No, City of Eugene is not a court of record. We're in the vast majority of municipal courts that are not. And I think these are really good questions. And there's been a lot of discussion amongst the different folks in our town, at least, about whether becoming a court of record would be a good thing or a bad thing, whether it really doesn't make a difference in how things roll. I guess one of the things to tackle, maybe in this group, maybe in a larger group in discussion, is the purpose of having courts of record versus not courts of record originally, right? And my thought only is that it's more for an efficiency's sake. So a lot of these things that can be done in a municipal level or on a justice court level can be handled locally, and then allowing these appeal options if they don't necessarily resolve locally. And if that were the case, then the next question is, does it make sense to then say, well, we can have more courts of record, because that's going to be make it more efficient for the circuit courts or for the process, maybe more fair to the appellant. But what does that do to the number of cases that are actually appealed in any given year to the Court of Appeals? And what is it that's actually being appealed from these different? And I think you just open up a lot of, a really big surge of things that may be appealed to the Court of Appeals if there were to be a lot more courts of record. And then finally, the efficiency's sake, I don't, fundamentally, at least in our court, there's really no difference in the proceedings or the process itself between, generally what we do and generally what circuit court does, being the local court of record. Our process is generally the same. We have dockets that have different names, and some of our timelines are different just because the resources are different. But fundamentally, the process is very similar. So I'm not sure that becoming a court of record or not a court of record would make a huge difference on how things actually operate in the court. Coming from the criminal defense background, I'm a big fan of not being a court of record, just because I think a lot of things can happen in a court not of record that may not be able to happen in an efficient and effective way, maybe at a circuit court level. But there are folks who don't agree with me on that, and that's fine too. So that's general overview.
Do you have a sense of the number of appeals that go from your municipal court to the circuit court, your court specifically? And then I don't know if you have any, from conversations with colleagues, a sense about the number or percentage of appeals from local courts to the circuit courts statewide.
I don't have that number, Ms. Duncan, and I appreciate the question. And my knee-jerk reaction is that the nature of the appeal would change if it were to become an appeal from a court of record, just because it's appealed de novo from the municipal level. And so if someone wants to have their case tried anew, they can do that. We have city ordinances, right? We have a city code where some of the ORS are adopted. That's the stuff that's required under traffic. But the rest of it is all city code stuff. And so they're appealing city code. to have the trial de novo. If it were to be a court of record, then obviously the things that they can appeal once things are tried at the trial court level would change dramatically. And that may reduce the number of appeals that we have. We don't have a ton, but we definitely have a decent small stream of those.
Okay.
Can you hear me now?
Yes. Thanks, Jim.
Sorry about that. I have a new phone and I'm just learning how to use it. Assistant AG Paul Brown told me that most of the appeals from courts of record are driving under the influence cases, which makes sense because in non-Dewey cases, usually what's at issue is a fine, a relatively small fine, and the cost of paying for preparation of the record, preparing a brief, oral argument is so high that it's not worth your while to appeal the case. Dewey's are because of the effect on driving privileges and insurance rates. And so anyway, Paul said most of the cases that come out of courts of record are Dewey's. But I was wondering whether it might be worthwhile contacting, maybe sending out a survey to municipal justice courts, well, to the 6 municipal courts that are courts of record, ask them what their position would be if we went back to them being not courts of record, and conversely asking the justice courts if we repealed the 50-mile limit, whether it's likely that they would seek to become a court of record.
Yeah, I think we should and will send a survey out to the justice and municipal courts asking the number of appeals they like, whether they're courts of record or not, and whichever way they answer why they are that way and whether they would prefer to be the other way, what numbers of appeals they are seeing, and any kind of complications they would see from changing their current appellate or their current status as of record or not of record. Okay. And with that information, that'll give our group, our larger group, kind of an idea about whether we should go to courts of record are efficient and there can be these appeals, or courts of record create more appeals for the Court of Appeals and that could have system-wide costs, or which way we should go on that. Any other thoughts on the courts of record policy question?
Another thought I had is I don't know whether this is true, but I've been told that the primary reason why more municipal courts do not become courts of record is because of the cost of purchasing, installing, and maintaining recording equipment.
Mm-hmm. That's interesting too, because if cost is an issue, one of the things that we're learning from the pandemic is just all of the different technologies that might be available. Now, that doesn't mean that they're going to, what we're able to do right here, right now, like just recording all of this easily through Zoom is transferable to a live courtroom setting, but there might be technologies that the state, if it was interested in, or could be available to reduce the cost of recording. But the challenge of course, with justice and municipal courts is they're not state courts and they're scattered throughout and have all sorts of different funding sources. So that is a challenge. Okay. And yes, John.
Okay, can you hear me okay?
Yes.
Good. I've been doing a lot of thinking about this, and I want to put things a little bit into historical perspective because I think I'm probably the oldest person here. Even when all the panelists are present, I still think I'm the oldest. I remember a judge from what was called the district court, which was not a court of record when I went to started practice in 71. And there was a judge named Shirley Field who was extremely unjudicious, making fun of Native Americans' last names. The American Civil Liberties Union had volunteer lawyers that came to her court and sat in it. And just to make sure that there were witnesses to what was really going on. And it turned out that the Oregon Supreme Court issued an opinion that was very critical of what was going on there. Now, I'm not so old to know who he was, but I think it was Oliver Wendell Holmes said that sunshine is the best disinfectant. I think an appeal, and the threat of an appeal, just bluntly, the threat of an appeal deters unjudicious conduct. And when things happen in a not a court of record, mischief happens. I've had it myself, where I moved to have a court reporter, just asked the judge to have a court reporter record a proceeding in a municipal court, and it was denied on the basis of we've never done it before. I asked to tape record it, denied. And as a result of that incident, I testified in front of the legislature in support of a bill from a Lane County representative from Springfield who, on her own, non-lawyer, presented legislation that passed that made it optional. And so when I heard somebody say repeal the statute, would eliminate courts of record for municipal or justice courts, I cringed. And with all due respect, I think one of the things that keeps judges, quote, honest, close quote, and I don't mean, dishonest financially or any other way, but one of the things that makes judges obey the law is the ability to appeal and have a record and a written decision. So one of my radical ideas, and I looked through all of this, not all of it, but looked through a lot of the stuff that we're having to deal with. And this is like trying to take 1,500 strands of spaghetti off of a white wall that have solidified in red sauce, and trying to figure out all the intricacies of this. Jim's done such a tremendous job. The Henderson versus Smith case that I sent to him that says that you can transfer a case from a justice court, municipal court, on the filing of a motion under Henderson versus Smith. There's a reference in the material that Jim presented about ORS 484. Well, the vehicle code used to be in the 480 numbers, but now it's not. It's in 813, 801, 815. And I don't even know that the statutes that are relied upon in giving you the right to transfer something from municipal court or justice court to circuit court are still in effect. And we could spend tons of hours, well, people that are hired or clerks or whatever, to try to solve all this. But I think that it's worth looking at to just say all circuit municipal courts are courts of record, period. And all appeals from circuit court, from municipal court and justice court go to the Court of Appeals in the same language as per Chapter 138 for appeals from circuit court to the Court of Appeals and the Supreme Court. Same thing. And I want to let you know from a practitioner who's now retired that the amount of ignorance on the part of the individuals, lawyers, that practice routinely in municipal court and justice court is astounding. The questions that I've seen that are presented show just a total inability to understand the morass of that spaghetti on the side of the wall. I don't know how to do it. And I think the cleanest, simplest solution is just to say, all justice and municipal courts are court of record, support for that. Sunshine is the best disinfectant. In other words, to make judges, prosecutors, defense lawyers, police, whoever obey the law. And the heck with the rest of all this complication. Let's just make it simple the way that the litigants know how to do it in circuit court. And money, balderdash. People are not going to, the sky is going to fall. All the Court of Appeals and the Supreme Court get inundated with all these municipal and justice courts appeals. Not so. Money costs a lot of money to do that. And most people are not going to take, to spend the money to do an appeal. And when the municipal or justice courts say that they can't afford it, well, number one, there's a possibility that the state could pay for it. Number two, these municipal and justice courts are cash cows. Just look at the one on Interstate 5 down by just north of Eugene. They just rake in the dough. So there's money for these courts make, and that's just part of the cost of their doing business.
Okay.
Sorry for being so radical, but those are my ideas that I've thought about this for a long time.
Okay, I think we will hear different viewpoints on this, and it will probably be that, I mean, we'll see what we can do. I expect that there'll be different viewpoints, and part of our role is to gather those viewpoints and think about those. I know we have the courts of record, John, and there's lots of things to think about. If, as you were saying, an appeal to the Court of Appeals is more expensive and is going to deter people from appealing, is it easier for someone to go from the justice court to their circuit court? And so would that be better for litigants who want to bring an appeal? Like, would requiring everyone to go to the Court of Appeals create cost disincentives or obstacles for people to appeal? So, okay, so it's,
I would like to
Yeah.
add, and I know that some of the criminal defense lawyers will want to kick me in the shins when I say this, but I think that it's sensible to eliminate trial de novo appeals.
which it's, so that is our,
I should say a second jury trial. Let me say it that way, because I don't want to get back to courts of equity and court of law. But to eliminate an appeal from a justice or a municipal court where you get a new trial in circuit court, eliminate it.
And that leads us to our second point, which is the transfer of misdemeanor cases to circuit court. And so, as John's just mentioned, when you're in the local court, you have the option of transferring into the circuit court and just skipping over the justice or municipal court and going straight to circuit court. That's an option that is available, and it could be an efficient choice for a litigant to make. And then alternatively, if you don't do that, then you go through your local court and then you have your de novo appeal to the circuit court. And I'd like people's thoughts on that. That is the existing process. It seems like you can't really eliminate that if the lower court is not a court of record. So what are people's thoughts on the de novo appeals? That's just what we have now. And John, I know you're saying you'd like to make every local court a court of record, and then you wouldn't need to have these de novo appeals. But if that's not the case, it seems like this is just how the system would have to work. If you have a local not of record court, you would go to the circuit court for a de novo trial.
So can I jump in with a question?
Yeah.
In aid of the discussion. So I want to be clear on the understanding, because I've had pretty good arguments from several folks that I respect on that transfer process and what it really is. And so if a court not of record, municipal court, I'll start with the municipal court because that's what I know best, is a court not of record, and it's adopted the ORS, right, as its code. So if someone were to want to transfer, it's a little bit easier to do because everything is the Oregon revised statute. Where I'm in Eugene, the city adopted the city code forever, and so we have ordinances that mirror or look just like the ORS, the wording taken just from the ORS. Let's say as an assault, Class A misdemeanor, for an example. There's debate on whether that charge could be removed to circuit court because it's a city ordinance, and the argument being that that expands the jurisdiction of the circuit court. It wouldn't have been able to be filed there in the first place, and that's sort of potentially limited to things that could have originally been brought in the name of the state. And as an example, potentially like the traffic crimes that the municipal courts have to adopt under their code. So I just wanted to ask that question, get thoughts on that, because I think that shapes a lot of the answer in terms of what the existing practice really is, and then whether it should be changed or not. Does that make sense? The question? Just, I don't know, I can't hear you. I think I'm.
There we go. It's 2 clicks. So the question is, what is actually transferable? Is it only the state offenses, things that could have been brought in the state courts originally? And Jim, if I can get your take on that.
My understanding is that it's misdemeanors under state law only. Although I do recall reading an old statute that suggested that municipalities have the authority to adopt misdemeanors, but I didn't think they did. But whether the misdemeanor is adopted by a city or it's under state law, those are the only offenses that can be transferred.
And so the percentage or amount of cases that we would be talking about is going to be some subset. And even if you have, like you're saying, Judge Gill, even if you have really the same crime, but it's under the city code, it might not be transferable. And so I'm wondering how large a concern is this transfer? Do you see, for those of you who've practiced in it, when do you see transfers being requested? And is there any reason why we wouldn't want that to continue, the option of transferring to continue?
May I speak to that?
Mm-hmm.
And Jim, I really would like to, I wish we could have a private talk about this in advance, but I question whether or not Henderson versus Smith, which is referenced on page 2 of your policy issues paper. It's B, transfer of cases in municipal court, page 2. It says that the Henderson versus Smith says under ORS 484-0302 and 484-0102, when a municipal court tries a state traffic misdemeanor, it is exercising authority as a justice court. Therefore, ORS 5102, a defendant may transfer the case to district court. Well, Henderson versus Smith was written in 78. And I think that 484-0302 and 484-0102 have been repealed. And I do not believe, but I haven't checked it, I do not believe that in what we now call the vehicle code, which is 801 through 815, 16, 17, I don't think that 484-0302 and 484-0102 have been enacted. And I think, and Judge Gill may be interested in this, I think that if you go look at it really hard, if that's the case, Henderson versus Smith doesn't apply anymore because the statutory foundation upon which it is based is gone. And that's what I said before about all these strands of spaghetti that have stuck to the white wall. And you know, like I said, I'm sure that there's some defense lawyers that are going to be mad at me for bringing this up. But Jim, do you know whether or not there is a statutory equivalent of 484-0302 and 484-0102 alive today?
I don't know. But I guess I understood Henderson versus Smith to say that municipal courts are in essence justice courts for this purpose, so that any offense that is a misdemeanor under state law can be transferred. Any misdemeanor under state law charged in a municipal court can be transferred to circuit court. So I think the question is, what is the nature of the offense being charged? If under the traffic code, under the modern traffic code, traffic offenses are not misdemeanors, then they would not be subject to being transferred. But my understanding is that there are other misdemeanors that can be charged in municipal court. Any misdemeanor committed within the jurisdiction of a city, I think, can be charged in circuit court.
Well, my point is that without those two statutes with 484 in front of them, my money would be that Henderson versus Smith is no longer good law. And that just takes care of a huge problem if I'm right. Maybe I'm wrong.
So if there are how frequently do you see transfers, Judge Gill? Do people try and go to the circuit court on the misdemeanors when it's an option, if it's at all an option under the way crimes are charged there?
That's a really good question. And it doesn't happen too often, but I think the perceived obstacles keep a lot of things from potentially being transferred. There are a lot of cases that come through with the idea that they're already going to appeal as opposed to just simply transferring. And I think it's because there's the belief, whether it's substantiated in old case law and statute or not, that they wouldn't be able to transfer to circuit court.
Okay.
And I think there's some folks that would argue that you couldn't even transfer, even though it makes sense to be able to transfer something that's charged under the traffic offenses portion of the vehicle code, right? Mm-hmm. That makes sense that you would be able to do that. But I think that there are a lot of folks, and I'll speak for my county, but in talking with other folks, other counties, I think it's also the belief that, no, you can't do this if it's a municipal code, like if it's a municipality, unless they've adopted that specific ORS and they're using that ORS.
Which is interesting because they're still going to be able to appeal, right?
Exactly. I mean, so for efficiency's sake, let's just get it up there and cut this bit out here at the municipal trial level.
Because it's not like an idea that the circuit courts are ultimately not going to be able to resolve something because it's a city ordinance. It's gonna come to them anyhow on the appeal. Absolutely. So what I'm hearing both from John and Judge Gill is that it's not entirely clear how this transfer process to what charges it is going to apply. So if nothing else, our group could, if there's reason to retain the transfer process, clarify the offenses to which it applies.
Yes, clarification would be outstanding.
Okay. And so we may not have a real good sense of how useful this would be because people may not understand its availability currently.
Yes, ma'am.
Okay.
Just talking really quick. Looks like that Judge Cross has joined us as well.
Okay, great. Good to see you, Judge Cross. It looks like we've pulled you from the bench. If you need to step back away, we'll understand.
I may have. My pro tem fell through, so I just finished my first small claim. The second on some very well done statutory arguments on behalf of the defendant, a VP of an auto body and frame repair shop. Anyway,
Okay. We were just talking about transferring cases from the local courts to the circuit court before having the full trial at the local court, trying to figure out how frequently that is utilized. And
in criminal matters.
yeah, misdemeanors. And whether, and Judge Gill and John were saying that it might not be clear exactly when that transfer process or when that transfer option is available to folks.
I thought I don't do any criminal in justice courts. I believe it's 10 days.
Okay.
If I'm not mistaken by the statute. And I actually brought that topic up. We had a justice of the peace conference last week in Bend.
Oh, good. Okay.
And I brought that up, and my colleagues, this is anecdotal, we're saying that there's very, very few cases that actually where the defendant requests the transfer. And I just asked whether or not they might be able to provide some data
Okay.
for that. I'll see what we can find out.
Perfect. Perfect. Yes. And we're also talking about the need for our group to do its own outreach and survey probably on any number of these issues. And it would include how often cases are transferred, what are the obstacles that people see to transfers. As a just general theoretical matter, what does the group think about having this transfer process available? It could be efficient, and it appears like that's its objective. Do you think that it is something that should be available?
I say yes, absolutely.
For those of you who can't see the chat, Jessica has put a citation to ORS 44030. Jessica, did you want to talk about that as well?
Yes, sorry. I thought that was the easiest way to communicate, but 484030 was renumbered 153565, and then it was repealed in 1999, but I've just put what it originally read, and it was just a jurisdictional statute that seems to parallel 221339, which talks about the concurrent jurisdiction of municipal and justice courts. And then 484010 was just a definition section that talked about, the definitions of traffic crime, traffic offense, things like that. I know we've moved on, but I thought in case somebody wanted to check.
The way my screen is set up, I'm glad that Sandy pointed that out because I didn't have the chat visible. Okay, so that helps with transfers. Anything more on transfers before we move on to interlocutory appeals? Okay. The interlocutory appeals were interesting to me. And I wanted the group get a sense of what the group thought about it as I was understanding it, Jim, and you can tell me if I'm misunderstanding it, but it is that you could have a proceeding in the local court and then an interlocutory appeal could be brought to the circuit court, even though in courts that are not of record, that appeal is, or that case is going to be relitigated in the circuit court if someone wants to appeal. Is that right?
With respect to justice courts, it's a writ of review proceeding. And as I said in my memorandum, it's kind of odd that there are separate statutes for both misdemeanor cases and civil cases, but not violation cases, that the statutes say, notwithstanding the right to appeal, the defendant can seek, or actually either party can seek a writ of review. Municipal courts don't have the writ of review, but they have this true, what I would say, a true interlocutory appeal that can be taken, but only when the defendant has challenged either the constitutionality or the validity of the municipal ordinance. that the defendant has been charged with. So it's kind of an amalgamation of remedies, and I really don't understand why we need them. But then I don't practice in those courts, so I guess I would yield to those who actually practice in courts to let us know whether the writ of review, well, and I guess I would also say that I think under the writ of review statute itself, without any other statute, parties could seek a writ of review with respect to both justice and municipal court. So I don't see the purpose of the two statutes applicable to justice courts authorizing a writ of review. And then I have issues with the municipal court interlocutory challenge.
So if we can start at just the very basic level, Jim, it's right that if there is at least some interlocutory or mid-proceeding option to bring an appeal, even in cases where you're going to get a de novo trial. Is that right?
Yes, yes.
And so what do people think about that? That seems to me something that the group should consider, because if you are going to proceed to the circuit court and get a de novo appeal, why should there be this mid-trial interlocutory appeal or writ of review at the local court? Judge Gill, do you see those writs of review or interlocutory appeals often?
No, no,
Okay.
not at all. And not to say that they wouldn't happen, but there was a case, and I can't remember, a long time ago, but it really had to do with a non-criminal matter that came through that I think forms the thought that really the interlocutory stuff really isn't necessarily available, especially to the prosecution. And so it's really not used very often here. At least I haven't seen any requests. I haven't heard of a request or a motion to do that, especially once jeopardy attaches during the trial.
Okay. And as I understand it, since the circuit court proceeding would be de novo, I mean, my one worry would be, is the interlocutory option there in the local court, because there's going to be some loss of appeal right by either party if that's not there. And I don't know if anyone has a sense of that, whether this, and it's in all likelihood going to be the state. Is there something that the state won't be able to do or challenge if this interlocutory option isn't there? I guess that would be like, are there limits on whether the state can seek a de novo appeal in the circuit courts?
Right. I think that's pretty much the area. People can correct me or add to it, but the majority of the city's ability or the prosecution's ability to appeal anything is extraordinarily limited after a trial begins. So any sort of pretrial ruling or procedure can be appealed, I think, fairly readily. But if there's something that is just really, let's say, untoward, let's say Jim's nightmares that he's described from the defense side actually happens to a prosecutor in the wild, wild west of the justice courts and municipal courts, then the city wouldn't really have the ability to address those things, again, once jeopardy has attached. So I think that's probably the main area that comes to my mind right away. I think the defendant, because they have de novo, they actually probably have the rights plus if they have the ability to do the interlocutory stuff.
Okay.
So a couple more wrinkles. The statute that's applicable to misdemeanors charged in a justice court, it says that the writ of review can be used where the constitutionality of the statute or other proceedings that may affect the final judgment can be reviewed. The one that's applicable to civil cases just says errors appearing on the face of the judgment, as does the one applicable to misdemeanor cases. So I think as I read these statutes that technically speaking, and both of them say either party can seek a writ of review. It seems to me that apparently you could, with that, once the justice court enters a final judgment, either party can either appeal de novo, or they can seek a writ of review
Okay.
as to the judgment. And to me, that makes no sense whatsoever.
Okay. So it sounds, so so Jim, at least you see it as possible that there's one way that these statutes can be read, that anybody could appeal anything coming out of the local court de novo to the circuit court.
Well, I wouldn't use the word appeal. I would be
Okay.
careful to say the writ of review, because the writ of review is of legal rulings only. You don't get a new trial of the
Okay.
fact. So it's the writ of review is limited to legal issues on the record made in the lower forum. But both statutes say either party can seek the writ, either as to an interlocutory order or as to the final judgment.
Okay.
Now, that's for misdemeanor and civil cases only. Neither of those statutes apply to violation cases.
Okay.
But as I said, I think under the writ of review statute itself, a party could seek a writ of review with respect to a violation charged in justice court.
Judge Cross, I see your hand.
Yeah, in small claims proceedings, at least in justice courts, there is a statute more specific on appeals. It's 55.110. And what that says is it's an appeal. If you get a judgment rendered against you, so if you're the defendant and the plaintiff prevails and gets a judgment against you, you can appeal that. If you're the plaintiff and there's a counterclaim judgment that's awarded, you can appeal that. They don't make it very easy. You only have 10 days to do it, and you have to post the entire amount of the judgment, either with the court through a check or cash, or I suppose we would be comfortable with that. But anyway, they have to post it with the court, and then and then pay the filing fees to the circuit court, which and probably I think in Washington County it totals $290 or something right now. So they don't make it easy to do. I don't know why it's 10 days as opposed to 30 days like every other type of appeal, or by and large. Well, I do know. I think it's to chill the ability to appeal.
And do you have, I mean, I was going to ask about that because I think that you had commented on that. And I don't know if you know from colleagues or anything, the history of the 10 days or no. Okay.
I don't know how far back that goes in terms of the existence of the statute. It may go back to the very beginning of it. I'm not sure.
Okay.
But they do use the language appeal in the statute.
Mm-hmm.
And it doesn't flat out say that it's a trial de novo, but that's always been my impression.
Mm-hmm. Okay.
Since we're not a court of record.
I'm just speculating, but I'm wondering whether the 10-day limit was imposed because small claims court, as I recall, have jurisdiction in FED cases. And I know there's a desire, particularly on the part of landlords, to expedite any appeal in a FED case.
There is, but this particular statute is limited to small claims. It's in the small claims chapter as opposed to the other in chapter 52.
Oh, so a small claims court would not have jurisdiction of an FED case?
It wouldn't be a small claim. The justice courts have jurisdiction over FEDs, as does the circuit court. But small claims, but it's not a small claim proceeding.
I think and so there's the RLTA, the Landlord Tenant Act, and we can check, and they probably have their own timeline, but if they have a timeline there, and that could very well be expedited. And if there is one there, then there's not really a separate base. There's not at least an obvious basis why we would have a 10-day deadline for these other small claims, which are going to be contract and property matters, right? Judge Crowder?
They have to be claims for monetary amounts of $10,000 or less, or for return of specific property.
Okay.
Okay.
So on this interlocutory appeal issue, it seems like we need to focus on why you would come from your local court to your circuit court mid-trial. It appears that that could be because if the state is unable to do that mid-trial, then they will have no ability to challenge the local court ruling. And so that might be the reason why this mid-trial exists. But then for our group, there would be questions of if that's the need for the mid-trial, whether the mid-trial appeal is right. I'll just say appeal is too broad. So that sounds like something we should be keeping an eye on. I don't know if people think that there's a problem. It doesn't sound like this comes up all that often. But it does seem like it would be unusual to have all of these opportunities to challenge mid-trial or through a writ of review when you could ultimately go to the circuit court for a de novo. All right.
And that is the circumstance with respect to municipal court. The right to an interlocutory appeal is limited to the right of the city to appeal the municipal court judge's determination that the municipal ordinance is unconstitutional or invalid.
Okay.
Now, one of the reasons might be that, of course, to do the appeal to the circuit court ultimately, then there's costs involved. And so it might be the notion of, yeah, you may have the right to appeal, but it's, again, like I say, in a small claims proceeding, they make it rather onerous and difficult to do so. And in any event, no matter what type of case it is, you're gonna have to pay fees to the circuit court. And so it may be just to may exist to avoid the necessity of those fees being incurred.
Like as a separate proceeding with its own fees. Do you have any sense, Judge Cross, about when you have this mid-trial effort to challenge something, whether there are fees paid to the circuit court?
So I've been here about almost 5.5 years now. I've never had anybody do any type of interlocutory appeal in any of my cases.
Okay, so it sounds like this does not come up
Yeah.
all that often. And if there's to be an area where parties are going to want to preserve this, it is most likely going to be where you have some decision probably adverse to the state that the state can't appeal after a judgment of acquittal or something like that. Okay, so this doesn't come up a whole lot. Okay. Jim was leading into the next item on our list, which is number 4, which is that we have these special rules for appeals from municipal courts that are limited to the constitutionality. And Jim, it's like sometimes it's phrased as to the ordinance, usually. Is that right?
And they always refer to the charter provision or ordinance.
Ordinance. And so, Jim, am I correct in understanding that that is a substantive limitation on appeals in municipal violation cases that isn't present in any of the other appeals?
Correct, except that the statute respecting justice, respecting misdemeanors charged in justice court says you can use the writ of review where there has been a challenge to the constitutionality of the state statute. So there's a little bit of similarity there, but it's limited to that.
Okay. So would it be correct that our large group should discuss whether or not appeals of violations should be limited to constitutional issues. They're not if you're coming out of justice court. Well, are they if you're coming out of justice court, Jim?
No, they are not. They are not limited. What's fascinating is that the writ of review statute itself does not explicitly refer to constitutional issues. And so that may be why there are statutes specific to justice courts in misdemeanor cases, because it was felt that maybe the writ of review wouldn't apply to those. But clearly the city one is well, this is something else that I point out in the memo. In a couple of places, the statute refers to constitutionality of the charter
You're right.
provision or ordinance. In other cases, it refers to the validity of the charter provision or ordinance, which to me is different.
So our group needs to understand the limits on municipal appeals and whether they're limited to constitutional claims, and consider whether, if that is different from justice court appeals involving violations, why is there that difference? And whether that, so whether the difference should exist at all, and whether, like you say, Jim, it should exist for between justice and municipal courts. And then if that limitation should exist, then we should be clearer. We should clarify what that limitation is. Is it a limitation to challenges to the constitutionality or the validity of charter or ordinance?
And if the rationale for the government, whether it's the DA in a justice court or the city attorney in a municipal court, if the justification for the writ of review or interlocutory appeal is to give the government a remedy in the event that the justice or municipal court strikes down the charge, it shouldn't matter whether the judge struck it down on constitutionality grounds or some other ground. If the government can't go forward with the case, they ought to have a remedy to get that reviewed at least by a circuit court.
Okay. Yeah. Okay.
And can I just jump in with another, just a question, for clarification? So Justice, you were saying the first big question is, the statutory language seems to suggest that a city or a municipality can put a limit on what can be appealed out of its charter. It can't limit things, let's just say for simplicity's sake, those things that where there's a challenge to the constitutionality of the ordinance, right? So the first big question is, can and should municipalities really be able to do that? And the example goes back to, or a question goes back to my example of, a city adopts an ordinance that mirrors an ORS for a Class A misdemeanor or for any misdemeanor, but let's just use the assault misdemeanor. If the language is exactly the same, if a city were to be able to put a limit on what can be appealed out of its charter, then it's basically putting the discretion goes back to a police officer in terms of where they issue their cite when they arrest somebody in a place of dual jurisdiction. So in the city of Eugene, if a police officer makes an arrest and they can cite under the ORS and have it go through circuit court, or they can cite under the stat or the local code and go through the municipal court, that officer is deciding then and there whether this person is going to have the ability to appeal any conviction at trial if the city charter says you can't appeal these ordinances. So did I get that right?
I think the state statutes limit the ability of the defendant, let's just say, if the defendant wants to challenge a city, well, if the defendant goes to trial in the justice court, and I'm sorry, no, in the municipal court on a violation, there is a statutory limit on what the defendant can appeal, as I understand it. And the limit is the only things you can appeal out of the justice court on a violation are challenges to the constitutionality of the ordinance or charter. So it's a statutory limit on the scope of the appeal. Right, Jim? Is that right?
No, I think what the judge is referring to is that there's a statute in ORS chapter 221 that suggests that a city has the authority to impose a limit on appeal even to justice, even to circuit court. And I believe the original justification for it was something like if the fine was like $10 or $15 or $50,
Okay.
it's just too small. Even with respect to circuit court, to civil cases heard in circuit court, ORS chapter 19 imposes a $200 limit that you can't appeal a case that involves less than $200. But I was unable to find any statutory authority for a municipality to impose a limit. And so I think we need to clear that up.
Okay. But we have a state statute limiting appeals by dollar amount. And so there would be a question about whether the states could preclude an appeal from whether this.
No, the statute that I referred to only applies to civil cases filed in circuit court.
Okay.
There is no state statute that I know of imposing a limit on appeals from justice or municipal court.
Okay.
And Justice said that we have violation cases, in cases in a justice court that's not a court of record. They my understanding is they appeal there to de novo
To circuit court. Yeah.
If it is a court of record, then that's obviously different, and that's
Mhm.
covered as any other
Mhm.
appeal would be. But I'm so sorry, folks. I have to run again because my second small claim on the docket did not settle.
Oh.
A fenced down neighbor dispute, so it's going to be a party.
Well, thanks for joining us when you could. We
I'm so
appreciate
sorry.
it.
I probably won't get back in before this is over, so I'm
Yeah.
so sorry for that. But I will certainly look forward to our next meeting.
Okay. Okay.
Thank you, Judge Cross. We appreciate it.
But thank you, guys.
So Judge Gill, you were saying, yes, there could be a concern that the local jurisdiction could put a limit on appeals. And if they did that, then as long as someone was charged under the local ordinance, that ordinance would kind of be protected from review, and the implementation of that ordinance at the local level would be protected from review.
Right, and that would, obviously, the inequities are pretty
Yeah.
straightforward from there.
Yeah. Okay.
Thank you.
Anything else on substantive limits, the limit on violation appeals from municipal courts, limiting it to constitutional issues?
Well, and that's really one of the bigger issues that I saw that the work group would have to wrestle with is, let's say that the municipality does not impose any limit on appeal of conviction of a municipal violation. Defendant can appeal to circuit court, but the defendant cannot if the circuit court affirms the conviction, the defendant cannot appeal to the court of appeals unless the appeal involves a challenge to the constitutionality / validity of the ordinance that
Mhm,
it was convicted of.
mhm.
And as my memo lays out, at least from 1925 on, the case law suggested that there was no right to appeal any other issue out of circuit court. But that because of subsequent legislation, that may have changed.
And Jim, you
but
think it
here-
might have been inadvertent?
Yes,
Mhm.
and unfortunately, I may have had a I may have had a role in that. But apart from the question of what is the current law, the broader question is, what do we think the law should be?
Right.
Because at the work group, we're free to propose something different or to propose that we make it clear that we want the old law.
Right. Okay, so we are going to need to identify a potential lack of clarity in the current law on this limit, and make a determination about whether that limit should continue to exist. And if so, then propose clarifying language.
Correct.
Okay. And that gets us to our last item from Jim's list, which is whether appeals to the Court of Appeals and violations should be treated like criminal appeals or civil appeals. And that's a very general statement of it. And Jim, it seems like this may be one of our easier issues in that right now, under the current law, most of the procedural steps for these types of appeals are linked to the same steps for civil, general civil Chapter 19 appeals. And you're suggesting that really the process should be similar to or the same as for general criminal appeals under 138. Is that right?
Yes.
Okay.
As you may know, from the written comments that were submitted to Sandy, questions arose regarding when does double jeopardy attach? When does statute of limitations kick in? And when, what is the effect on the right to a speedy trial if appeals are taken under the civil statutes? All those questions, I think, can be avoided if we make clear that those appeals are under ORS Chapter 138 pertaining to criminal cases.
So that, any thoughts on that? That one seemed perhaps the easy, one of our easier tasks, but important to clarify. So, okay.
Yeah, I think the only caveat there is that we need to make sure that merely because appeals to the Court of Appeals in violation cases are under the same chapter that applies to criminal cases, that does not mean that violation cases are criminal cases.
Right.
Involving right to counsel and other rights that are limited to criminal cases.
Right. Okay. Yes. Okay.
And actually, I think it's an interesting question. I don't know whether double jeopardy principles and statute of limitations principles and speedy trial principles apply to the violation cases. I just don't know.
Right. Right. Because if they're Sixth Amendment rooted, they may not be covered by the Sixth Amendment.
Yeah.
Yeah. Okay. Any other thoughts, comments, topics before we kind of move to next steps?
A quick question again, in terms of the Sixth Amendment comments there. So one of the reasons, I just want to say back what I'm hearing, one of the reasons to make sure we treat it the same as the criminal provisions that already exist is because there are some violations that could be considered as requiring counsel just because of the nature of the violation, how the violation was, how the violation came about. You know, they've got all these steps of criteria where someone may be afforded the right to counsel, even if it's initially filed as a violation or if it's a misdemeanor reduced to a violation. We just want to keep all that together so there's never really any question. Is that right?
That's a interesting point, a valid point. That may involve a real drafting challenge.
To leave open the possibility that in a particular violation with particular consequences that would trigger the Sixth Amendment, it would be a criminal case. But then, Jim, you're saying part of what we want to do, if saying these procedures for appeal are the same as they are for criminal cases, is to not automatically say all violations should be treated as criminal cases for the purpose of appeal, and therefore carry all of the rights that might come with a criminal case, when by criminal we mean criminal that would rise to the level that you have Sixth Amendment protections.
Yeah, if a city adopts an ordinance that defines as a violation of city law to drive while under the influence of intoxicants, and that same ordinance imposes a fine and imposes a sentence that would be the same as what a defendant is liable for, if the defendant were charged with driving while intoxicated in circuit court, then that obviously implicates Sixth Amendment rights.
But most of these, I mean, if they are true violations, and perhaps it's answered by the definition of violations, if they're true violations, they're not going to carry any threat of
You're right,
custody.
yeah.
And so those would be misdemeanors, and those could well carry all of the criminal rights. But if it's a true violation, it probably won't. And so maybe that line will be easier to maintain.
Yes.
I think 9.5 times out of 10, absolutely.
Right. Okay.
But I think that there are, especially with the advent of social media and other things, I think that that list of criteria of things that may, even if something were filed as a violation and it's just a true violation, as you say, everything leading up to that citation, if a lot of that criteria is met and argued well, the Sixth Amendment, the right to an attorney, could attach even though it's a violation.
Okay.
And vice versa. If you start off with a misdemeanor, which was, let's say someone's taken into custody, and that misdemeanor, it's a Class C misdemeanor, let's say it's a criminal trespass in the second degree, so real low level stuff. But someone's taken into custody and then later reduced to a violation by the prosecution at arraignment, there's real question as to whether that Sixth Amendment right attaches as well. So
Okay.
it's that 0.5 times where it's going to get muddy, and I think it's important to prevent that spaghetti on the wall that John keeps referring to.
Okay.
Further solidifying.
Okay. Good point. Thank you. And John, I saw, yes.
In case this has been recorded and it somehow finds its way in some form of legislative history, I think the record should make it clear that when there was the discussion of the Sixth Amendment, that really what we were not talking about was not the Sixth Amendment, but the Oregon constitutional principles that underlined Brown versus Multnomah County District Court, that said, despite the fact that DUI was a non-jailable offense under the Oregon Constitution, you had the right to counsel, court-appointed counsel, if indigent, requirement of proof beyond a reasonable doubt, even though the statute only required proof by a preponderance of the evidence, and the right to a jury trial. I'm sure that that's what everybody was really meaning. And so can the record so reflect that it was not Sixth Amendment, but it was the Oregon constitutional right with regard to counsel, requirement of proof beyond a reasonable doubt, and jury?
Right. I think what we're talking about here is just when we currently have the municipal violations, most of the procedural statutes say just treat these like civil cases. And we think that it makes more sense to treat municipal violations for appellate processes like criminal cases. Just for like what has to be in the notice of appeal, who needs to be served, all of those sort of appellate purposes, that it makes sense to treat them as criminal cases. But I think Jim is flagging and others are flagging, okay, well, if we're going, we don't want to, by adopting or linking to those process steps, suggest that we are changing whether these charges should be regarded as violations or criminal for any constitutional purpose, state or federal. Like if we just want to say, follow the processes that you would use for criminal cases, for these violation cases, that adoption of those processes isn't meant to change any analysis under state or federal law about whether the constitutional protections that go with a criminal charge would apply. Does that make sense?
Yeah, John Henry, would you be willing to send me the citation to that Brown case?
I think it's 276 Oregon, but I could be wrong, but I'll send it to you.
Thanks.
My memory is already demonstrated to be faulty. I was referring to Holmes when I should have been referring to Brandeis, and for that I apologize.
Okay. Anything else before we move to next steps? Yes, Jessica.
I was just going to say, if we do decide to treat these violation appeals under Chapter 138, I think it could be drafted so that we don't have that kind of implied treatment as a crime that we're worried about here, because there's a lot of places in the criminal code that do refer to violations, and we don't necessarily interpret that to mean that they should be treated the same as crimes. For example, the statute of limitations statute does cover violations, but that doesn't mean it's a crime.
Right.
But we would really need to be very specific as to what in Chapter 138 applies and what doesn't. Because where I see sometimes statutory references where it says something like Chapter 138 applies except where, it doesn't make sense. And we want to avoid drafting like that. We would just need to be really specific.
And I know throughout this project, Jessica, because there's so many cross-references, sometimes the cross-references are useful because you don't have to have the same processes set out in all of these different chapters. And they're useful because if it's determined in the context of one area that it would be useful to revise those processes, then they get revised all at once. But at the same time, if let's say all of the processes are in Chapter 138 and people revise 138, they may not also have an eye on all of the other chapters that cross-reference it. And so something that I've been thinking about throughout this is like, does it make sense to just say, here's the appeals for cases coming out of justice courts, here's the appeals for cases coming out of municipal courts, blah, 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 and have them kind of self-contained. And so you're saying, well, we can cross-reference Chapter 138 and just really be clear about what provisions we're intending would apply to these violations. What are the actual process provisions that we want to adopt? Another option, I guess, would be just to say, look at 138 and say, here's these steps that 138 sets out for appeals, and we would just copy and paste them into the municipal appeals statute. I imagine that's something that those different approaches, cross-referencing versus copying and pasting, is something that we can think about as we go forward. Okay.
Right. And also if we do decide to just have kind of a signpost that just says, for appeals of violations, these sections in 138 apply. Anytime those sections in Chapter 138 would be amended, we check every single reference throughout the Oregon Revised Statutes to make sure they all still make sense.
Okay.
And so that would be checked, but I guess the caveat is the group a future group that's amending something in 138 may not be in a position to make decisions about municipal and justice courts.
Right.
So, yeah.
Do you, from the legislative council perspective, have a preference? And I'll just say, like, basically between creating these self-contained silos, here are the appeal processes for justice courts, here are the appeal processes for municipal courts, and then here are the 138 processes for criminal cases and the chapter 19 processes for civil cases. Do you like to have them more siloed like that, and maybe there's just duplication? Or do you prefer us to have like one general system that's cross-referenced with some exceptions?
I would say generally I prefer to have kind of each system self-contained.
Okay.
However, it's definitely like a case by case
Okay.
decision, because if almost everything in that appeals series in chapter 138 is now going to apply to violation appeals from local courts, it doesn't necessarily make sense to cut and paste like every single one of those.
Okay.
So, and that as we get more into it, we could kind of make that decision down the road.
Okay. Yeah, because that's something I've wondered about throughout. All right. Well, if no one else has anything right now, let me just propose a next step for our small group. Sandy, remind me, we've got a June meeting for the large group.
Yep, I have it down for June 2nd, 10 to noon.
Okay.
That's a reminder about that as well. And we're still trying to grow the large group. John
Okay.
had good folks reach out to, and anyone else, as we keep kind of talking through this, especially in who you'd like to invite to the larger group, I'm happy to do that. But June 2nd is what we're planning on for the next meeting. We don't have another meeting scheduled for the drafting group at this point, but that may be a good idea while most people are here.
Oh, we've got people.
Yeah, it would be helpful if, when we had the discussion about whether to continue with courts of record, to have a municipal judge from a court of record, a judge from a municipal court not of record, and likewise justice court that could be a court of record, but for the 50-mile limitation.
Mhm.
And perhaps, well, I guess I think that would be, I think that one judge could represent the views of both sets of justice courts. Those
Right.
that are within the 50 miles and those that are not.
Okay.
The other significant person would be the DAs, because if in those cases where the DA has to handle the prosecution, the DAs may want to weigh in on whether they would like courts of record or not.
Mm-hmm. And I know, Sandy, we're trying to get trial court administrators, because they on both ends of these appeals, so the trial court administrators from the justice and municipal courts, and the trial court administrators, especially from any circuit court that is the recipient of appeals, especially I imagine there's Eastern Oregon circuit courts, because there's a lot of justice courts out in Eastern Oregon. So there's got to be one of those circuit courts that gets a lot of the appeals. So we will want trial court administrators from there. So what I propose doing is I'm going to try and write up a report and a guided discussion to the issues that are facing our work group. And there's the issues that are policy issues along the lines of what we've talked about today. There are also, fortunately, some simpler issues, which are just procedural issues about where is a notice of appeal filed, what needs to be in a notice of appeal, who needs to prepare the record, all of those things. And so I want to prepare a report and send it to this group for kind of editing and review purposes, to let me know if that report will be a useful guide for our next large group meeting. And so I will send that out within 2 weeks. so that you guys can look at it, maybe within a week, so that you have a chance to look at it, provide feedback, and then we can send it out to the larger group before our June 2nd meeting. So that's gonna come right up. So I'll send that out to you. Sandy and I and Krista will still try and grow some of the group. It'd be really great if folks would think about just have in your head, like, what are the questions that we want to survey local courts about. If we were to send an electronic survey, just keep those in mind. So that's my thoughts on our small group's next steps. And I'll communicate with you by email and through Sandy by email, and set up a means for you to give feedback on that report. And then we'll come together at the next large group meeting.
Just a second, did you want to try to schedule at least a next meeting for this group?
Yes, it's good. We're headed into, yeah. So let's look. We're meeting on June 2nd. How does about June 16 or 17 look for people?
If we could at all not have it on Fridays.
Okay.
I know that Friday works for a lot of folks. Unfortunately for me, I've got the most conflicts on Fridays.
Okay.
So I make that humble request. If it goes
Right.
the other way, definitely make it happen regardless.
I'm out those 2 days, unfortunately.
Okay. We could go earlier to June 9th, or later to June 23rd. No, it doesn't work.
I could do the 9th.
The 9th, how does that look for other people? 9th, 22nd could work.
I could do the 9th or 22nd.
I like June 9th works better for me.
Okay, and then that'll be right after we've had our large group. How about you, Krista, Jessica, John? June 9th. Great. Do people prefer the 10 to 12 or like 1:30 to 3:30?
10 to 12 for me. I like that.
Yeah, okay. June 9th, 10 to 12.
Got it.
Great. Anything else for the good of the group? No. Thank you all